He's Dave Gladish. He's an attorney. You want to talk to him? 219-845-1100. Let's go to George on line 3. George, what do you think?
Good morning. I think the stand your ground law plays pretty well with juries, but neither here nor there. My question is, Dave, with respect to the charge of the second-degree murder, is that the only charge, or does that contemplate lesser included offenses? I'm a little rusty on my criminal law procedure and all that stuff.
And usually
how's that factor in the lesser included? Will they get jury instructions, or if the evidence is there, or does it have to be part of the bill of information?
I would say in reference to, and again, every state's different. In the state of Indiana, that's a prosecutorial decision. Do they want to have it where the jury can weigh that and make a determination as to whether maybe it doesn't meet this standard, but one of the lesser included offenses, meaning a lower standard resulting in the death of the individual, he can be found guilty of. So it really depends on the case. Sometimes it's a trial tactic that the two sides decide on. Well, I'm going to go for the gusto. I want a capital murder conviction here. I want the death penalty versus reckless homicide or something.
No, I understand all that. I mean, when do they spring it? Do they have to do it now at the beginning, or can they do it after the evidence comes out and they meet with the judge and you guys haggle, or they haggle over the jury? You know, what's actually going to be put before the jury? Is that when they can do it, or does it have to be done up front and when they charge him?
You know, that's a very interesting question, and every state's going to have different procedural laws. In the state of Indiana, I think it can be brought up until the time of trial and before the jury's instructed as to what the charges that the jury's going to be instructed on. Now, what Florida's law is and what the procedural rules are for criminal cases, I don't know. That would be
George, let me ask you a question. What did you think when they came out with second-degree murder charges against Zimmerman in this Trayvon Martin case? Do you think they caved to public opinion, or do you think it was based on law?
I think that was part of it, and I also think, there may be a basis for it. I think there was a reasonable basis to contemplate those charges, given the fact that, with the police dispatcher and everything else, and I don't know what this guy's. I don't know enough about Zimmerman to understand his mindset. Some guys get really eager and gung ho when they've got a little bit of ostensible authority or power or whatever the case may be, and so I think it's a reasonable charge. But I could be wrong because I don't know. Like Dave, we're at a distance and we don't know how the whole thing shakes out. That's why I'm asking about the lesser included, because I'm thinking, well, because of the public pressure, they charge a second degree, and maybe not. I mean, but
maybe they just leave it and sit there. All right, thanks a lot, George. I appreciate it. Let's move on. Let's go to.
Let me say one thing before you move on to the next caller. There is another issue there in reference to the comments that George is making. The one thing he's talking about, they call it the John Wayne syndrome, where people walk in and they think, I'm not like John Wayne. I'm going to come in here and basically kick ass and take names. But the situation in reference to the trial, you said going to public pressure was an issue there. The judge is the ultimate gatekeeper as to what evidence comes in and what charges are going to be. So the judge is going to regulate the trial, and if the state fails to prove beyond a reasonable doubt to a certain level, it's the judge's obligation to take that issue away from the jury. So this may be a situation where this case is tried. Whether or not Zimmerman takes a stand, he's going to have to make that decision for himself. But in the end, the judge may ultimately weigh in and say, no, this does not meet this level of crime, so therefore I'm going to direct the verdict in favor of the defendant on that charge. So it's going to be very interesting as to what the charges ultimately are when the case is going to trial.
219-845-1100. Hi, Chief.
Good morning, gentlemen.
Good morning.
Wouldn't it have been better if the prosecutor had a grand jury on this, and wasn't Zimmerman running from Trayvon? Thank you. I'll listen to your comments.
Well, I'll say in reference to the second part, was he running? I have no idea. I wasn't there. And again, we've already seen that in the media that we're getting a skewed perspective as it relates to some of the evidence. After the second part, going to a grand jury, I think that we've seen in Florida with the Casey Anthony case and so forth, that a lot of jurors have received tremendous amounts of heat as it relates to their decisions. So I think in this instance that I applaud the prosecutor for her taking the heat upon herself and making the decision that I'm going to go forward with this and let the chips fall where they may. She made a decision to go forward with the charges, not put it in front of a grand jury. Do I think a grand jury would have indicted? Yes, because it is a prosecutory tool, and they are going to decide what evidence goes before that grand jury.
Just watching the CNN talking heads, though, there were attorneys that were critical of her not going to a grand jury because I guess some of them felt that, well, if she sends it to a grand jury and they don't come up with any charges, then, she doesn't have anywhere to go.
But a grand jury, everyone has to understand, it's not like a regular jury where the defense gets to put on evidence and gets to question and so forth. This is the prosecutor putting on their best evidence in front of whether it's 12, 16, 24, whatever the size of the grand jury is in Florida, and you get so many people to come back and give a true bill as relates to the indictment. It's a situation where if they can't get an indictment there, they'll never get an indictment.
From what I understand, sometimes you don't know what's going to happen in there, and they ran the risk of not getting an indictment that way, right?
I think it would be nearly impossible for them not to get one.
219-845-1100, Dan from Hessville.
Hey, how you doing, Jed? Hi, how you doing, Mr. Gladish?
Good morning.
I was just wondering, does the neighborhood have any of the responsibilities of the action of this person?
You mean the Neighborhood Crime Watch?
Yeah.
All right, hey, before we answer that, you got the dogs around?
No, I don't got them. I'm on a different phone right now.
Okay, all right. Next time you call, have the dogs around, will you, please?
All right.
All right, talk to you.
I heard that comment earlier. Squirrel. That was funny.
The Neighborhood Crime Watch that he's a part of.
Now, is it a corporation? Probably not. Is it just a loosely affiliated organization? I would say that there's probably nothing there unless it was a community that has actually hired him and he was acting as their agent. When you have principal-agent relationships, the agent can cause the principal to be responsible and have to pay damages, but I'm sure there's no insurance. I'm sure that there was probably no organization behind Mr. Zimmerman. Zimmerman will be exposed to a civil case, but if they find it's an intentional act, there's no insurance coverage, so the probability of the Martin family receiving any monies for this act is probably very little, unless Mr. Zimmerman is wealthy, but I'm sure he's going to go through any money that he has in defending himself in a criminal case.